Hello class! In this video, we are going to continue discussing on Unit 2 of our learning module. So in Unit 2, we are going to continue on the salient features of the RA 9285 or the otherwise known as Alternative Dispute Resolution Act of 2004. So I do hope that you will watch this video until the end. On our previous recordings, we have already discussed on Chapter 1 of RA 9285. So in this video, we are going to continue on Chapter 2. And Chapter 2 is all about mediation. So we have already discussed also some general understanding about the so-called mediation. But here, in this chapter, we are going to discuss on the provisions or the rules or procedures or guidelines that was set or that was mentioned or that was stated here under the Republic Act 9285, all about mediation. Okay, so let us start first on the scope of this or the provision or the scope of this so-called mediation under RA 9285. Okay, so the provisions of this chapter shall cover, it says here, voluntary mediation, and not only voluntary mediation but also court annexed mediation. So meron kasi yung tinatawag natin na, 'di ba, yung court referred mediation processes. So wherein meron yung supervision ng courts natin. Kasi yun nga, they are the ones who referred mismo kung na tayo ay dapat mag-undergo first ng process of mediation before trying or proceeding to solve our dispute inside the court. Okay, so that is also whether ad hoc or institutional.
Pag sinabi kasi natin ad hoc arbitration, it means parties agree upon a form of arbitration that is specific to a particular contract or dispute without referring to any arbitral institution. Okay, so unlike in the other arbitration process, they need to refer it with an arbitral institution such as the PICCR and other offices, okay, of arbitration offices. Okay, so yun yung pagkakaiba ng ad hoc arbitration with institutional arbitration. So just take note of that. Basta sa ad hoc arbitration, they did not or they don't refer the arbitration process to an arbitral institution. So parties lang mismo, sila mismo yung involved lang doon. Wala nang ibang arbitral institution. Okay, so yan po yung sinasabi natin ad hoc arbitration.
So here, another one that you should take note is the term mediation shall include conciliation. So, as we have discussed previously in our discussions, sabi natin mediation is different from conciliation. But here in this act, pag sinabi nating mediation under this Republic Act 9285, pag sinabi nating mediation, included na po doon yung conciliation. Okay? So, please take note of that. So next one, under section 9, still under mediation. So these are the we are going to continue on the confidentiality of information. So information that was obtained through the process of mediation. So sabi dyan, information obtained through mediation shall be privileged and confidential. So in short, mga information na binibigay po during the process of mediation ay hindi po yan sapilitan, okay, or hindi nire-require kasi privilege, sabi dyan. Pag sinabing privilege, kagustuhan mo yan, voluntariness. And those information that was taken during the process of mediation is also considered or shall be treated as confidential, okay. Yun, kapag ikaw ay whether you are the mediator or the party or one of the party of that certain issue, okay, or also you could be a non-party participant. Okay, non-party participant, ibig sabihin you were present during the conduct of that mediation. So ang example ng mga non-party na participant na yan is, kunwari kumuha sila ng stenographer. Okay, stenographer parang secretarial yung trabaho niya, wherein nire-record niya through writings yung mga pinagsasabi during the process of mediation. Okay, parang dun sa korte, kasi dun sa court proceeding meron yung tinatawag din nilang stenographer. Okay, so they could be classified or they could be termed as non-party participant. So yun, yung mga tao na yun dapat treat nila yung mga information na nailalabas during the process of mediation as confidential. So, otherwise, pag yan ay hindi nila tinreat na confidential, yun, pinagsabi nila, pinagkalat, or dinivulge yung mga informations na yun sa kung saan-saan, they can be punished or they can be penalized under this act. So we will be discussing those violations later on as we go on, okay, here in this chapter. So take note of that. And here, nasabi din dyan, a party, a mediator, or a non-party participant may refuse to disclose and may prevent any other person from disclosing a mediation communication. So, yun, hindi sila pwedeng ma-require or sabihin natin, pwede nilang i-refuse. Okay, kunwari, they are called to testify in court. Okay, sabihin natin yung issue natin hindi na solve doon sa mediation process. Kaya nandito na tayo ngayon sa korte. Okay? So, yun, inside the court, you were called. Sabihin natin, ikaw yung mediator during the process of mediation and then napunta na ngayon sa korte. And then yun, pinapatawag ka ng korte. Tinatanong ka dun sa some certain informations. Yun ay pwede mong i-refuse. Okay? So, you have the right na i-refuse mo na wag sabihin yung mga informations na nakuha mo during the process mediation. Okay? Pwede mong itanggi. And then, pwede mo ring pigilan yung mga ibang tao na kunwari nagte-testify and then they are part or sabihin natin they were once a non-member or non-party participant during the process of mediation na kinandak ninyo. So, pwede mo rin silang pigilan na wag niyong i-disclose yung information na ito na nag-gather natin during the process of information. So, parang yan lang naman po yung sinasabi dyan sa part na yan. Okay? So, just take note, every information that was taken during the process of information should be treated as confidential. Okay? So, sabi, additional here, we have here in the next slide, sabi dyan, confidential information shall not be subject to discovery. Okay, of course, kasi nga confidential. And then shall be inadmissible in any adversarial proceeding, whether judicial or quasi-judicial. So, adversarial proceedings, that is the process of lawsuit or litigation na sinasabi natin. So, whether judicial, so meaning doon sa court mismo, or quasi-judicial, or some offices that solves dispute resolutions, or disputes na hindi mismo yung mga korte natin na gaya ng RTC, MTC. Okay, so quasi-judicials, an example of that, sabihin natin yung the Office of Mediation Center, okay, or the PICCR, mga yun. So, those are considered to be a quasi-judicial offices. So, with that, any informations, okay, yung information sabihin natin na nakuha nila, okay, hindi nila pwedeng gamitin yan as evidence, okay, na i-present na evidence during the adversarial proceedings. So, hindi po pwede yung ganon. Okay, so next one we have here, however, sabi nyo, however, evidence or information that is otherwise admissible or subject to discovery does not become inadmissible or protected from discovery solely by reason of its use in mediation. So, parang sa CDI ninyo, yung natutunan ninyo na exclusionary rules. Wherein, meron kasi yung discovery or sabihin natin accidental discovery or plain view doctrines na sinasabi natin. So, if that is considered to be discovered due or solely by plain view doctrine, okay, then that could be treated as admissible as evidence. Okay, so yun lamang po yung mga instances na pwede nating sabihin or pwede nating magamit yung mga information na yun na nakuha natin as evidence in court. Okay, so yan lamang po yung sinasabi sa slide na ito. And then sabi dyan, in such an adversarial proceeding, the following persons involved previously in the mediation process shall not be compelled. So, as we have mentioned a while ago, pwede nilang i-refuse. So, pwede, nandito po yung the parties to the dispute mismo. Not only the parties, but also meron din dyan pati yung mediators. Pwede rin yung mga counsels nila kasi yun, they are present during the process of mediation. So yun, yung mga tao na yan, hindi mo pwedeng i-compel yan. And then, pati na rin yung na-mention natin kanina, the non-party participants. Okay? And any persons hired or engaged in connection with the mediation process. So, yun, as we have said a while ago, the stenographer, secretary, clerk, or assistant na hinire ninyo during the conduct of mediation process. Or any other person who obtains or possess confidential information by reason of his or her profession. So, in short, lahat ng tao na present during the conduct of mediation, they are not required or they cannot be compelled to divulge or disclose those informations that was taken or that was brought out during the conduct of mediation process. Okay, so yun lang po yung pinopoint out ng part na ito or ng slide na ito. So still in the confidentiality of information, we have here, it says, even though na the mediator was found out to act impartially, okay, or naging biased siya during the process of mediation, or merong dayaang nangyari. So even though na ganun yung nangyari during that time, during the process of mediation, still this act shall apply, or this law or the provisions nung batas na ito is still applicable pa rin. So hindi natin sasabihin na baliwala pa rin. Okay? So yun, even though na naging bias yung mediator, still yung mga informations na nag-gather during that time is or should be treated pa rin as confidential. Okay? So, kunwari, meron dyan si husband and wife, nag-aaway in terms of financial. Kasi yun nga, the properties. So, pinag-aawayan nila yung mga ari-arian nila kasi maghihiwalay sila. Okay, so yun, sabihin natin, husband and wife. And then, lumapit sila sa'yo. And then, they ask you to become their mediator. Okay, so you act as mediator between the dispute of husband and wife, okay, of that couple. So yun, yun nga lang, pinanigan mo, or sabihin natin, naging bias ka. Okay, pinanigan mo yung side ng husband. Okay, kasi lalaki ka, kaya pinili mo na panigan yung lalaki kasi yun nga, sabihin natin, naging bias ka. So, yun, still, yung mga informations na nag-gather nyo during that time, okay, the conduct of mediation process, yung mga information shall be treated as confidential pa rin, even though na naging bias ka. Okay, kasi yan yung sinasabi dito sa dito sa slide na ito. Okay? So, still, yung mga confidentiality of information is still applicable pa rin. Okay? And then, next one, it says here, a mediator may not be called to testify to provide information. So, as we have said a while ago, pwede mong i-refuse na mag-testify. Okay? So, kunwari, hindi nyo na-solve yung conflict during the process of mediation nung mag-asawa, hindi nyo na-solve. Okay, kaya ngayon, pumunta sila sa korte. Pinunta sa korte yung kaso nila. Okay, yung dispute nila. So, with that, yun, during the process of court proceeding, or yung court proceeding, pinapa-testify ka or pinapatawag ka. Okay, merong in-issue na subpoena ang court sa'yo. Okay, naka-address sa'yo na ikaw pupunta dun sa korte para mag-testify kay husband, para kay husband. Okay? So, yun, tinawag ka ng korte, pwede mo po siyang i-refuse. Okay? That is a privilege or that is your right. Okay? So, hindi ka pwedeng pilitin ng korte na mag-testify. Okay? And then, sabi pa dyan, if you were wrongfully forced or you were wrongfully subpoenaed, okay, or nag-testify sa korte, okay, or kinumpel ka, lahat ng mga ginastos mo during that time, okay, na pumunta sa korte or attorney's fees and any related expenses shall be reimbursed to you. So, yan yung sinasabi dyan. Okay? In this slide, we have now Section 10. So, Section 10 speaks of the waiver of confidentiality. So, ano nga bang ibig sabihin po ng waiver na ito or ng term na waive na ito? So, pag sinabi nating waiver or waive, it is simply means voluntarily refraining from using such privilege na binigay sa'yo. Okay, so paano mo nga ba i-waive itong confidentiality na ito na binigay sa'yo under Section 9 of this Act? So, yun, it could be done through writing, okay? Or yung sinabi dyan, through record. So, record lang ba yung na-mention? So, yun, hindi lang po record. And it can be also waived, okay? So, pwede mong sabihin, okay lang, kahit po i-public na lang po ninyo, hindi po natin iti-treat na confidential yung mga information na sinabi ko during our mediation process. So, okay lang po na i-publicize natin. So, yun, it could be done through writing or record, or if not, orally. So, yun nga lang, if orally, kailangan there is the presence of the mediator na sinasabi dyan. Okay? So, hindi pwede na orally na kahit wala yung mediator. So, it is clearly defined or stated under this act that there should be the presence of mediator. Okay? In order na ma-official natin na ma-waive yung confidentiality ng mga informations na dinidisclose mo during the process of process of mediation, okay? So, yan po yung isa dyan na sinasabi. And then, another one, it says here, a privilege arising from the confidentiality of information may likewise be waived by a non-party participant only if siya mismo yung nagbigay or nag-divulge ng information na yun, okay? So, again, pag sinabi nating non-party participant, those could be the stenographer na hinire ninyo during the process of mediation, or if not the stenographer, meron tayo yung secretary. Okay, so kung sabihin natin an example, okay, so si secretary, siya mismo yung mga nagsabi ng mga informations na yun. Okay, so yung mga informations na sinabi niya, yun ay pwede niyang sabihin, okay lang, kahit yung mga sinabi ko during the mediation process, okay lang po na yun ay mai-publicize, okay, or may publicly disseminated. Okay, so yun, pwede niyang i-waive yun. Pero hindi niya pwedeng sabihin na or hindi niya pwedeng i-disclose yung mga informations na galing naman sa mga ibang participant. Okay, yung pwede lang niyang i-waive is yung mismong mga informations na sinabi niya. Okay, so yun po yung sinasabi dyan sa part na ito. Okay, so next slide, we have here still on the waiver of confidentiality. So what if dito we have a situation, if a person suffers loss or damages in a judicial proceeding against the person who made the disclosure, so what would be the effect dun sa taong nag-disclose? So ano yung epekto nun dun sa taong na disclose nung confidential information na yun. Okay? So, yung mga pinagsasabi niya kasi naka-apekto dun sa taong tinutukoy niya. Okay? Or dun sa other party. Okay? So, it suffers loss and damages. So, anong mangyayari sa kanya? Okay? So, can he still avail or does he have the privilege that was mentioned under Section 9 of this Act? Okay? So, pwede ba niyang ma-avail or he is entitled of the confidentiality of informations? Okay, so the answer is no. Okay, so na-mention dyan, a person who discloses confidential information shall be precluded from asserting the privilege under Section 9. Okay, so precluded meaning he will be prevented from the privilege stated under Section 9. So, ano yung tinutukoy ba ng Section 9? So, yun yung pinag-usapan natin kanina. Yung tinutukoy niya is about confidentiality of information. So, ano pong ibig sabihin yan? So, lahat po ng mga sasabihin na niya, yung mga i-disclose na niyang information is hindi na siya covered na or hindi na siya maituturing na confidential. Okay? So, yun po yung epekto nun dun sa taong nag-disclose ng information if it damages, okay, or it loses, or it gives, or the person suffers loss or damages, okay, in the judicial proceeding. Okay, so yun po yung tinutukoy dyan sa slide na yan. Next slide, still on Section 10. So what if, dito naman, what if the communication or informations that was disclosed causes prejudices, okay, or pandaraya, or biasness, okay, or in other words, still the same with the previous slide na na-mention natin kanina, or in other words, causes damages. So ano naman kaya yung epekto nun dun sa taong nag-disclose ng informations na yun? So still parehas din nung parang kanina. Okay, so if it causes biasness during the judicial proceeding, yung mga information minention niya or dinisclose niya, still, yung mangyayari din sa kanya is same as to what was mentioned during the previous paragraph. So, ano yung nasabi natin kanina? The person who made the disclosure shall be precluded from asserting the privilege under Section 9. So, yun, automatic, hindi rin matitreat as confidential yung mga information na sasabihin niya. Okay, so yun yung mga effect, okay, or yun yung sinasabi dyan sa Section 10. Okay, so kindly please take note of that.